you're not on the list, then they'll probably deny you access. So,
Okay.
so if they say no, what's the intention?
Well, the intention is basically just to practice our rights to be here.
Okay.
It's, based on the law that
Okay.
you're allowed to be in public hearings. So we'll sort of converse with them and see what they say.
Okay.
We're both commenters and we're members of the public.
Okay. Only interveners and registered media can attend the hearing.
Okay, we're actually here to contest that under the law. So according to the Supreme Court of BC, of Canada, the public is allowed to be at public hearings. Yes, so we're here
It's
to
protected under our Charter of Rights and Freedoms, under the open courts principle, and so it's actually enshrined in the Constitution that we're allowed to be at these hearings, and we'd like to actually attend them and be able to hear what's being said.
Sorry, that's not that. So Section 11 of the Energy Board Act establishes the board as a court of record with all the powers, rights, and privileges of a superior court. And as a court of law, the board must be bound by the open court principle in the same way as any court. In addition to any legal requirement, as a matter of policy, it is clearly desirable that a body exercising powers as significant as the board should operate according to the open court principle.
So if you refuse us access, you're actually operating in opposition to your own act, which is bound by Canadian law. Is that what you're wishing to do today?
I am following through with the procedures that we've established for this hearing.
Which are unlawful.
Which are unlawful.
So you're
and against
violating
your
the
own act.
Constitution?
So you
So,
operate
Yes or
in
no?
opposition to the Canadian Constitution?
so there's no evidence of any threat to the proceedings that meets the legal test to keep the public out. That's why we think that closing these hearings to the public is unlawful. And so would you be able to allow us in today in order to be able to watch the hearings? We're not intending to disrupt the hearing process, and we'd simply like to attend the hearings.
The board's already made the decision, and it's not my decision, and I'm following through with the procedure that's established by the board. I'm a staff member of the board, but I'm not the decision maker.
But are you a
So-
Canadian citizen?
Yes, I am.
So your rights are also protected by the Canadian Charter of Rights and Freedoms, and we are trying to also...
It's not my decision.
It doesn't matter.
It actually does.
Well, it does, but your standing here is a decision. Your very presence here is your own decision.
Yes, I'm making this decision
So you're making
do
a
my
decision
job.
to exclude
do
other
my job.
Canadians?
I made the decision to do my job.
Are you
my
your
job is to
or are
follow
you
through
beyond
with the
your job?
procedures. I'm following the procedure. The decision's been made by the board, and I'm staff.
So can we talk to whoever's your boss?
You are illegally preventing us from being in there. Regardless of what your own internal views are, you're preventing the public from attending a public hearing. Do you understand that? It's not something that has to be appealed. It's contained in Canadian law. So you're operating in opposition to Canadian law. Whether or not this is your own internal thing, you're supposed to act as a court. And in acting as a court, you have to permit us to enter. We have no malicious intent here. We're here to listen and evaluate the evidence for ourselves. And if you don't allow us in here, you're operating
I'm not
against your
allowing
own
you in
act.
here. If you're
Okay.
not an intervener or registered media, I'm not allowing you in.
Doesn't that bother you as a Canadian citizen?
That I'm doing my job? No.
So I'm not asking about that. I'm asking as a citizen. Like, if you step outside your role for a moment to consider if you were standing on this end of the line, doesn't that bother you that you're not allowed into something that affects your life and
The
your health?
board is here, as they've said over and over, to
Right.
hear from the registered interveners. They have to hear what they have to say. And that's what
We
they
don't want to
do.
see here. We want to hear as well. We
And
just
you
want to
can
hear their evidence.
You can hear everything they have to say.
However,
That's not public.
I applied to be an
Live stream.
That's not
intervener
public.
because I'm directly affected by this pipeline.
Then you have to
proposal.
apply?
I applied as to become an intervener. However, I was demoted by the board itself to simply be a commenter. And so then now I'm not even allowed to see the hearing process itself, which is like unprecedented. But there's been no case where the open courts principle has actually been violated here in BC, other than this court itself that I've ever seen. And so I don't understand how I could ever have been allowed into this hearing process, even though this pipeline is crossing like directly through where I'm living. And the fact that I'm not allowed to be part of this process and that I'm not allowed to even watch people's presentations that they've spent hours upon hours putting together and actually be physically present and supporting community members by actually having people in those chairs. Like, we've seen so many images of all of these empty chairs inside, and the fact that you aren't allowing people in, that you've rented a huge space and it's sitting empty instead of allowing members of the public in that are not even like, we aren't even here to disrupt the hearing process. We simply want to attend the hearing process.
I understand that.
Restrictions on public access to hearings must be justified. The Supreme Court has further held that the presumption of full public access can only be displaced if it is justified by a serious risk to the administration of justice that is real, substantial, and well-grounded in evidence, and if the restriction impairs the right of access as little as possible under what is called the Dagenet-Mentep test. So if you're not performing any of this, and you're not evaluating any of the potential risk for the hearings based on our presence, then you're not only operating in opposition to what our rights and freedoms are as Canadians, but specifically under Section 26. So you stated Section 19, I'm stating Section 26, which allows us access.
Essentially, we came here today, as we said, to exercise our rights, and we find that as we come here today to exercise those rights, to attend a public hearing under the open courts principle, that our rights have been offended. Not only our rights and our freedoms to be here have been offended, but also as people and as the public and as people who are concerned about this pipeline, we are offended that the National Energy Board is not allowing access to these hearings. And there's been a lot of talk about the National Energy Board losing the trust of the public, and we're here as the public to say, yes, you've lost our trust. You haven't even let us in the room. And why should we trust you when you don't even trust us as members of the public, as intelligent adults who are concerned about this pipeline? But you don't even trust us to go into the room and sit and listen to something that directly affects and concerns us. So we're here to express that loss of trust, and we will also file a motion to have it changed as best as we can.
Thanks, Margaret.
Thank you for hearing it. Okay.
Thanks. I can appreciate your willingness to stand here with a group of people and hash things out, so I hope you'll accept a shake. Thank you. Cheers.